I spent the best part of a year or so investigating Icac. And that's nothing compared to the Australian's legal affairs editor, Chris Merritt, who's been exposing the corruption body in New South Wales's dodgy and improper practices for 5 or 6 years now. He's written hundreds of stories on it. As a result of his work and mine as well, there was a parliamentary inquiry and Icac was entirely overhauled with substantial changes made, including having 3 commissioners. But it's still inadequate and there's not enough oversight over a body that can access anyone's phone calls, text messages and web searches. It's nothing short of a scandal. Chris Merritt joins me now live. Welcome, Chris.
Hi, Shari.
Now, if Icac investigates someone who we consider very dodgy or corrupt, you know, like the former Labor politician Eddie Obeid, then you kind of think, oh, well, these practices might be fine. But it's when they use these sort of practices on people who are innocent that it becomes a problem. And that has been an issue, hasn't it?
That is exactly the problem. Everybody needs a fair shake, even the bent. If you don't give the bent people a fair shake, how can you be sure that they're actually bent? The innocent who have suffered at the hands of Icac in New South Wales, it's just extraordinary what's happened, and there's no move I can see to make fundamental change to the way Icac in New South Wales operates. If the federal parliament endorses this scheme, which they've now signed off on, what they're in fact doing is setting up a parallel system of justice without all the safeguards for human rights and liberties that are the hallmark of the Australian legal system. So
today the federal government did support a motion to have an anti-corruption body, but they've come out against Cathy McGowan's bill, 200-page bill. What were some of the problems with the bill as you see it?
It's too close to New South Wales. It sidesteps things like the privilege against self-incrimination. There is no right for counsel to cross-examine witnesses. Just like New South Wales, counsel for a witness has to seek leave from the Commission before they can do fundamental things like cross-examine a witness as to their credit. They might be a dodgy witness. We've seen that in New South Wales, where dodgy witnesses have been put up, given public evidence, and their problems have not been exposed until later. There's a series of things.
What about the power to arrest? I mean, that was something quite extraordinary that's part of this bill.
Yes, it's tucked away in clause 144.
But for anyone else who wants to go look it up.
But it's there. Clause 144 would give staff of this agency the power to go and arrest people. And it's worse than that. It would give the new commissioner of this federal agency the authority to instruct the AFP officers what to do. So AFP would lose their independence. They'd become an arm of this kangaroo court.
So the AFP could be told by this corruption body to go and arrest someone.
Go and do this, and you would have to do that, or it would be an offence.
And often these agencies are used as political witch hunts, really. You know, the agencies say that whoever makes a complaint is automatically a whistleblower, but often it's the politicians' enemies who are making the complaints and using this sort of body to get revenge and to further their own careers.
These agencies are too powerful a weapon to be put within arm's reach of any politician, and we've seen that in New South Wales. New South Wales Icac is not independent. During the notorious coal inquiries, there were undisclosed contacts between the government of Barry O'Farrell and Commissioner David Ip. Now, Commissioner David Ip is one of the people currently pushing for a federal Icac.
Now, in one of the famous cases in New South Wales, of Margaret Kineen's case, investigators turned up to her home, seized her mobile phone, but they didn't have the proper warrants and documentation, and they then, quite extraordinarily, turned up a week later and reenacted the seizure with a videotape running, reenacted the seizure. I mean, these are some of the very dodgy tactics that are used by these agencies.
It was unlawful conduct, there's no doubt about it, and the reason they get away with this is there is nobody looking over their shoulder. The system that this federal bill would establish would again replicate the limited oversight that is already in place in New South Wales. There would be no fundamental appeal. An appeal would be limited to points of law, factual errors, and every organisation makes factual errors, but there will be no capacity to appeal on the facts of a wrong finding by a new federal integrity body.
One of the the reasons that people cite for needing a federal Icac body is that politicians are getting away with corrupt behaviour. There are, you wrote in your column on Friday, 16 bodies. We just heard from Christian Potter. He thinks there's 13 bodies, but there already are a lot of corruption bodies federally who are meant to scrutinise public servants and politicians. Do you think they're doing their job adequately?
Look, if they're not, I'm not going to say one way or another. It's not up to me to make that determination. But if the community and the parliament thinks that the existing, and actually I think there are 26 of them,
26 agencies?
26 integrity bodies. That's what the Attorney General's Department told a Senate inquiry in 2016. But if those agencies aren't working properly, their heads should be knocked together, their budgets should be expanded, their jurisdiction should be expanded. But the answer is not to create a 27th. I can't see the benefit of doing that. It's just spending taxpayers' money when we've already got plenty of agencies out there. And let's, for the sake of the argument, assume that they are inept. The task confronting the Parliament and the government is to address that, to overcome that and make it crystal clear that the existing bodies are sufficient. There's no need to create a kangaroo court that sidesteps all the fundamental rights and freedoms that are so important in this country.
A Fairfax story today highlighted some flaws with Ackley, and they hadn't dealt with the corruption or supposed corruption of a border force official. I mean, so clearly it's not. There are concerns about how they're operating at the moment.
Granted, but the answer is not to resort to authoritarianism. And that's what we're facing here. This is left-wing authoritarianism. There is no doubt about it. There's no other way of describing a system that would strike down fundamental rights that are a core of not just the Australian legal system, but Westminster legal systems, common law justice everywhere. It's incredible that we have not seen human rights law centres and the Human Rights Commission itself come out and point to the fact that our fundamental freedoms are at risk.
And you know why they don't do it? Because it's politicians whose lives are getting ruined and public servants, and who's going to stand up for a politician when they're so hated by the public on the whole?
Look, you're right, but the jurisdiction of this body is so wide that it could actually include ordinary people as well if they have oblique dealings with the Commonwealth.
Chris, thank you so much.